Well, we are following that breaking news this afternoon. The Supreme Court blocking President Joe Biden's vaccine or testing requirement for large businesses, but it will be allowed to go into effect for certain healthcare workers. The ruling came down just earlier this afternoon. Employment attorney Gary Phelan is joining us now to weigh in on all of this. So, Gary, I know there's like 2 points here. First, we're going to start with businesses if we can. This mandate, of course, was for businesses with more than 100 employees. So what does this mean now, Gary?
Well, first, I think it's important to see what the court's ruling. They focused on the fact that there was nothing unique. It wasn't an occupational hazard necessarily, and secondly, that OSHA did not have the authority to impose this requirement that has such a broad impact. The example they use is lifeguards and healthcare workers were subject to the same requirements. I think now there's not going to be a federal mandate for 100 or more employees, but that doesn't mean there's not going to continue to be employers imposing mandates or adopting vaccine or testing mandates. More and more employers are doing them, particularly in light of Omicron.
So you think that they'll still be able to mandate vaccines? If a business wants to do that, they can?
Absolutely. And that's why, again, employers have been doing this across the country, particularly in areas such as the Northeast throughout the past year, long before the OSHA mandate was imposed. And most employers have been finding that it's very effective, that it reduces the number of sicknesses, illnesses, that a lot of employees, as much as some employees may leave, some employees may stay because of it. Also that the consumers, the people who go to restaurants would prefer to go to places where they know people are, the employees are vaccinated.
What about those who maybe didn't want the vaccine and then got it because of this mandate?
Certainly nothing you can do to change that now. And that's something that, again, I think it's important to distinguish this. The court didn't say that vaccines are somehow prohibited. That's what I think some of the perception. It's just saying that this particular mandate imposed on employers with 100 or more employees cannot be enforced. They can't be forced to do it. It doesn't mean they can't do it voluntarily, just as many employers have been doing across the country for the last year.
And Gary, quickly, we have about 30 seconds. How about healthcare? That still stands, right? So will anything change here?
No, and that's what the majority of the court focused on, the fact that the unique aspects of healthcare workers did justify the mandate. The example they used was the axiom of first do no harm, because the unique aspects of what healthcare workers do, that it was justified.
All right, Attorney Gary Phelan joining us. Thanks so much for your time. Very informative.
Thank you, Courtney.